I'm Stephen Gold, the author of The Return of Breaking Law. Payment protection insurance policies. Billions have been paid out by banks and other financial institutions to customers who were induced to take one of these policies out when they signed up for a credit card, a loan or mortgage, though they didn't need the policy or they didn't want the policy. Why were the banks or other providers of credit so keen on you having a policy? Probably because they collected a fat commission when the policy was taken out from the insurance company which issued it. If the commission was excessive, you could have a claim against the bank or whoever provided the credit if you weren't told it was being paid to them, how much it was for, or the true amount. Excessive? Well, regarded as excessive is usually anything above 1/2 of the premiums due under the payment protection policy. The claim would be made on the basis that the relationship between you and the bank or whoever was providing the credit was unfair. That's thanks to the Consumer Credit Act of 1974. If you've already made a payment protection claim through a financial conduct authority complaint or in any other way and got back all the premiums you paid under the payment protection policy, then you have reached the end of the road and can fast forward me until I talk about something else. But if you haven't had a penny back or you've not had all the premiums back, then it may not be too late to pounce now, so long as any previous payment hasn't been accepted by you in full and final settlement of all claims.
But you're talking about policies which could have been taken out years ago. I thought there were strict time limits for starting a legal claim.
Well, there are. What is key is when these time limits start to run. In one of these claims based on excessive commission, the time limit would be 6 years from when your legal right to make a claim arose.
When does that legal right arise?
This is worse than the Spanish Inquisition. Well, that's an issue on which the Supreme Court has just ruled, and the ruling could cost banks and other institutions an estimated cool £20 million. There were 2 appeal cases being decided by the Supreme Court relating to credit cards taken out with the Royal Bank of Scotland, where the payment protection policy covered credit card payments in the event of death, accident, sickness, or involuntary unemployment. The bank failed to disclose to either customer that most of the money paid for the insurance didn't go to the insurers but was retained by the banker's commission. Even to this day, the bank hasn't revealed the exact size of that commission. Reversing the Court of Appeal, the Supreme Court held that the 6 years started not when the last payment protection premium was paid, but when the agreement with the bank or whoever provided the credit came to an end. And that means that if the agreement is still running, the 6 years haven't even yet started. Provided you haven't previously made a county court claim relating to an allegation of excessive commission, you can make one now. If your credit agreement didn't end over 6 years ago or is still in existence, even though it's actually too late now to go to the Financial Conduct Authority. There's a template court form in my book.
The Return of Breaking Law?
Well, I was too shy to say. Page 339 and page 340 and 341.
So shy.
This thing is bigger than both of us.
So sarcastic. One firm of solicitors called Harkus Parker have started a PPI commission claim in the County Court of Birmingham on behalf of over 2,500 people. You can apply online to join up if you're so disposed. They charge you 35% plus VAT on money you recover. Otherwise, you can do it yourself. Before launching a county court claim, write to your bank or other credit provider for commission details. There's a template letter.
In my book, The Return of Breaking Law.
Pages 338 and 339. The threat made in that template about a court application is likely to be more productive than seeking information by way of a data subject access request. Anyway, good luck. Keep abreast of the latest legal news on my blog. You can reach it at breakinglaw.co.uk. And if you sign up for alerts of my latest posts, not only will my publisher think I'm more popular than I actually am, but you'll be able to order a copy of my book, The Return of Breaking Law, and probably save a couple of quid on the price.